Hey folks, welcome to Sten Reacts. The woke mind virus infects Rhode Island Superior Court in the Jane Doe transgender suicide case. Yes, the woke mind virus is indeed alive and well. False narratives clearly ruled over the judge in this case, as he delivered what can only be described as a torturous decision in denying Jane Doe's petition to rescind the Rhode Island Department of Education's unlawful transgender regulation. Hey, folks, welcome to not in the dugout. This is Sten Reacts. A little different. This is me, my commentary only. What I witnessed yesterday or earlier this week, depending on when you're watching it, in Rhode Island Superior Court under Judge Joseph McBurney can only be described as an abomination of common sense and God's truth. Now, you might have noticed that I'm looking over here. I'm trying a little new format here for Sten Reacts. I've got so many notes on my computer screen, on my hand. These are all my notes from the hearing yesterday that I need to refer to, that I can't make it seem like I'm looking directly at you in the camera. So I see a lot of reactors on TV, they're looking away at their screen over here when they're talking. So I'm going to try it, see how it looks. We'll give it a go. I'll talk to our producer and our team, and you can send your feedback to info@rifreedom.org if you'd like. Let me know how it went. But let's get going. So I'm looking over here. I'm looking at my notes, both on my computer screen and on my handwritten notes from the hearing, because no recording devices are allowed in the courtroom. So let's go with it and hope you enjoy it. But hey, this is going to be a long Sten Reacts. So grab, hit pause, go grab your favorite beverage, adult or soft drink, coffee, tea. I've got a lot to say. What I saw yesterday was maddening, absolutely maddening in Rhode Island Superior Court. There is no truth. There is no honesty. And to see our judiciary, which is supposed to interpret the Constitution, not fall prey to political narratives, what I saw yesterday was an abomination, and not even an attempted suicide attempt by a groomed and secretly transitioned 10th grade girl could dissuade this judge from the false woke notion that school policies that encourage gender denying transition and give special rights to those confused about their gender, that those policies somehow protect students from harm or from discrimination. I'll get into both of those in a minute. It was an abomination. I'm gonna come back to the court proceedings in a second, but it's important you get a little background, both what's going on, at least from my view, what's going on nationally, what's going on with the Jane Doe case, and then we'll get into the actual what was discussed at the hearing this week. There is a Christian revival. You may have seen it from many places going on in America. It's true. God equals truth. God equals freedom. God equals truth. That's what our nation was founded upon, those principles. But apparently neither God nor truth exists anymore in Rhode Island's judicial system. And that's the key issue, the key issue that we're going to make the theme of my reaction today is this question. Is the biological noun sex, not the act, but the biological noun sex, ambiguous? Biologically. Is it ambiguous? Is it not binary? Well, the whole basis of this Judge McBurney's ruling against Jane Doe, and I'll tell you about Jane Doe in a second, was that the term sex is indeed ambiguous. And because it's ambiguous, therefore it's subject to the interpretation by woke or agenda-driven state officials And therefore, those state officials have the right to promulgate rules or policies or regulations that comply with their broad interpretation of the ambiguity of the term sex, the noun sex. That was his ruling, that Commissioner of Rhode Island Department of Education had the right to interpret sex, clearly written and intended originally to just mean binary sex, male, female, boy, girl, man, woman, clearly written decades ago to mean that. But he felt that it was ambiguous enough that the Rhode Island Department of Education had the right to falsely claim that state law cited that you cannot discriminate on the basis of sex. And then they added illegally, unlawfully, or maybe, however you want to say it, gender identity, and, sexual orientation and all that stuff. It does not say that in state law, but this judge said that the Department of Education had the authority to interpret it as if state law went that way. That's why he said, no, Jane Doe, the plaintiff, her complaint to have this unlawful ride regulation rescinded would be denied. All right, that's it. All right, let's do a little background first. What is this Jane Doe case all about? Before I get to that, I'll come back to that. I'm going to go back to this Christian revival in America issue generically first, then we'll get to Jane Doe's case or her story, and then we'll get to what happened in court. As I mentioned, young people especially are flocking back to Christianity in America. It's a revival. You've seen some of the videos of the baptisms, mass baptisms going on in college campuses and elsewhere. And why? Why? In my view, it's because people are sick of being lied to and having false narratives shoved down their throats by the media, by government officials, by agenda-driven advocates who have no desire to follow God's truth at all. God's truth, God is truth. And like I said, millions of people are discovering, or maybe they're rediscovering, this fact that God equals truth. And but apparently, like I said, that doesn't matter, sadly, in Rhode Island's judicial system. And you all know, in the woke world, everything is upside down. Everything. Common sense, millennia after millennia of traditional norms no longer matter. They're eschewed. I mean, take a look at this headline from Virginia. Hold on, let me bring it up here. Here we go. Take a look at this headline from Virginia. Multiple boys in a Virginia high school face suspension from Loudoun School District in Virginia because they were uncomfortable with a female who was pretending to be a boy, but they were uncomfortable with the female in their own locker room. And the female was taking video in the locker room, which should be a private space, regardless you're male or female or who's in there. But yet it was the boys who were suspended for that. Is this reality? Is this common sense? Well, this is the same level of ridiculous, ungodly, non-common sense, non-lawful thinking that was displayed by this judge. Look, the transgender argument is based on gender fluidity, right? They claim that this is from the woke left. This is from left-leaning progressive sources. Their political desire and their desire to have transgender and intersex students accepted as part of DEI, diversity and inclusivity, they've purposely chosen to distinguish gender from sex. They admit that sex is binary, but gender is fluid and can be pretty much anything they want. But virtually all biologists, all medical professionals, and everyone like you and me who believes in God understands and asserts that biological sex is indeed binary. It's immutable. and it's rooted in reproductive biology. It's distinguished sharply from gender. Well, at least there, I don't agree with that. I mean, gender, I think, is the same as sex, but they claim that it's gender fluidity. They've never made sex fluidity arguments before, but yet this judge, in claiming that sex is fluid, that sex, the term biological sex, is ambiguous, even goes on beyond the furthest, craziest, wokest, extremist, radical, most radical arguments from the left, in claiming now, in his ruling, that sex is ambiguous and fluid. I've never seen this before. These arguments for sex fluidity, I've never heard of this before, except for this Judge McBurney. And it can only be seen as being politically motivated and certainly only pseudo-scientific. I mean, he cited cases from Webster's dictionary, to sort of support the claim that biological sex might not mean what it seems. But these crazy, out of the mainstream, non-legal arguments should never influence a constitutional judicial proceeding, or for that matter, a judge's ruling. I mean, such angles, has actually happened to Jane Doe. This kind of angle and interpretation of sex actually caused harm to Jane Doe and her daughter, as I'm about to explain to you in a second. It actually harmed the parent and the child in this case. Not to mention sports or other medical, girls competing in sports, boys competing in girls' sports, the dangers of that, and not even considering the chemical castration, the physical mutilation, or the emotional manipulation that happens for these gender-denying students by school officials and doctors. The idea of fluidity in sex has been rejected as bogus, both by the scientific and religious communities. Clearly, mainstream thinking does not believe sex is ambiguous. It's clear that the term biological sex is binary. All right. So what is this Jane Doe case all about? All right. First, you can see we've covered this extensively. If you go to oceanstatecurrent.com/Jane-Doe, you'll see all of our interviews, articles, both locally, nationally. This has gained some national attention. Here's the Daily Signal, which is the Heritage Foundation. Parents Involved in Education wrote a wonderful piece on it. It's getting national exposure. But if you click on this one, Major Case Developments, I want to quickly take you through the chronology of what happened to Jane Doe. All right. So in September of 2022, the daughter wanted to start being referred to as they and requested the school change her pronouns. Nobody notified Jane Doe, the mother. She repeated that request in October, and nobody notified the mother. In October, a third time she asked, she wanted her name to be changed in the Aspen database, which is the official database that most school districts use to keep track of student records. Again, the email was finally the principal and others agreed to make that change. And according to school records, she was referred to as they, and she would be treated as a boy in school. But when she went home, she lived the life of her natural and God-given identity as a boy. So now she's living dual lives as a boy in school and as a girl at home. So they grant the request. All right. So that's the first part of it. Then later on, in 10th grade, 2 years later, this girl tries to commit suicide in front of her parents. She can't live with she can no longer cope with the stress of living this dual identity. Was she protected? Was she protected by these laws, by these policies, by RIDE's regulations? They always say, if we can just save one young person's life by giving them a safe environment that conforms with their delusions, then it'll all be worth it. Well, what about if you were to lose one life, as we almost did in this case? What about that? That doesn't matter, of course, because it doesn't fit the agenda. Only then, in the hospital, and through all that process of, what the heck happened here, did the mother learn that the daughter had been being secretly transitioned for years, without her knowledge, behind her back, with her divorced father's approval, but not with the mother. And then when the mother asked for time off from school, she actually worked in the same school there, the West Warwick School District. That's where this all happened. And the same mother worked in a kind of a menial job capacity, important, but not a high level job. I think it was in the cafeteria. When the mother asked for time off, as should be allowed with family medical leave, she was denied. But when she took the time off anyway to care for her daughter, who had just tried to slit her wrists and commit suicide, her contract was not renewed. She was essentially fired. So not only did she almost lose her daughter's life, she lost a relationship, which is now the case with her daughter, and she lost her job. And guess what? Because she lost her job, she lost her house. Now she's living with, Jane Doe is living with her mother. So daughter Doe is out of her life. Jane Doe's house is out of her life. Jane Doe's job has been taken away from her. No, these RIDE regulations protect families, protect students. Baloney, BS. And that's the Jane Doe story. So with that as a backdrop, that's why Jane Doe became the plaintiff in the case, submitted to the General Assembly, to the Superior Court, saying, look, I'm going to get into the legal arguments here in a second. These RIDE regulations were improperly, unlawfully constructed and promulgated, first of all. And second of all, they are shown to have harmed this family. Those are the two arguments. That's why Jane Doe was the plaintiff. Okay. All right. So let's go back to the case now that you know briefly the story. And again, that's why I'm wearing this hat. Okay. In the bottom, it says truth seeker. God's truth. God's truth was completely ignored in the hearings. All right. Back to my notes over here. All right. Now I'm going to be looking at my handwritten 4 pages of handwritten notes from the hearing. I'm going to be all over the place on this. I'll do my best again to try to keep some sanity to it. But in a reaction, you don't pre-write everything out. You just react to things as they happen. So I couldn't react live in the courtroom, but I am reacting to my notes and from what I heard yesterday. There are 2 arguments. I pretty much already explained the one. In Attorney Gregory Piccirilli, who's a hero in all this, he's represented many other clients across this state who have been harmed by government overreach, especially during the pandemic. Those who were fired or otherwise censored or for refusing to comply with mask mandates or the bogus COVID vaccine. And he's won some cases, unlike many attorneys who he's won many cases. But of course, this court system is woke. This judge was woke. And what we saw on display yesterday, as I'll explain here, the wokeness of this judge, the TDS infection. So not only is this judge infected with the woke mind virus, he's infected with Trump derangement syndrome, as I'll explain as we go on here. So the arguments, the complaint has 2 pillars to it. Jane Doe's complaint filed by Attorney Gregory Piccirilli. 1, the regulation does not stand on lawfully constructed grounds. The regulation basically cited 2 things in it. It relied upon a false interpretation of state law. As I mentioned, state law only says that there can be no discrimination on the basis of sex. But yet the regulation said that state law, if I can find the passage, also says no, state law on the basis of sex, gender, I can't find the exact wording, but then it added gender identity, gender preference, sexual identity, sexual preference, or something like that. That was not what state law said. So that was the first question. How can you say state law is the basis for your regulation when state law doesn't say what you said it said? Okay, that's number one. Number two, in the regulation, they also say, and at the same time, while we're complying with this non-existent state law, or this manipulated wording of state law, our regulation also complies with federal law at the time, federal guidelines, which the Obama administration had put out in 2016. Right? They put out a regulation providing this transgender guidance that was quickly adopted Rhode Island Department of Education. So, hey, we're complying with state law. No, you're not. And you're complying with federal guidelines at the time. Yes, you were. Okay. But here we are at the time of this complaint. We're in a new world. We're in Trump's second administration, and those Obama guidelines have been rescinded. The new federal guidelines say sex is binary and that special transgender rights, there are no such thing, by the way, special rights for special interest groups. We all should be protected and should enjoy the same rights. We don't have the concept of special rights for special interest groups in our country, but yet the left believes we do. So now, under the Trump administration, those Obama guidelines are gone. So now, not only is there no state law, there is no state law that officially can these regulations be based upon, because they purposely misstated state law. And now they're no longer in compliance with federal law. All right, so that was the first argument. Second argument, and this is, I think, and this is the one that was not even addressed yesterday. This judge, in his decision, I'm going to get into how he decided the first one, but this judge in this decision completely ignored the second argument made in the complaint by Jane Doe and her attorney. I'm going to read to you, quote, I'm going to quote here. Pursuant to Rhode Island General Laws 42-35-37, quote, the validity or applicability of any rule, that's by any agency, any state agency. So we're talking about any rule, it is a general rule, not Department of Education. This is general state law. The validity or applicability of any rule may be determined in an action for declaratory judgment. That's what they were seeking, a declaratory judgment that this rule should be declared invalid and therefore be rescinded. In an action for declaratory judgment in the Superior Court of Providence County, when it is alleged that the rule or its threatened application interferes with or impairs or threatens to interfere with or impair the legal rights or privileges of the plaintiff. End quote. So if any rule put forth by an agency, and that's a rule is something put forth by bureaucrats and agencies, a law is something put forth by the General Assembly or lawmakers, okay? So any rule that interferes with the legal rights of the plaintiff or privileges should be declared in a declaratory judgment as invalid and should be rescinded. That's Rhode Island law. That's what happened to Jane Doe. Her rights as a parent were ignored. Her rights to instruct the upbringing, the education, the medical treatment of her daughter were violated. Yet this judge did not care, did not even address it. Jane Doe never came up in his, I don't know how many pages that was. He spoke for about 20, 25 minutes reading it. So it had to be 25, 30-page ruling. But in all of that time, not once did he mention Jane Doe other than to say, this is the case at hand, Jane Doe versus the Commissioner of Education. Jane Doe, the plaintiff in this case, was not even a consideration. She's the whole point of this case. She was not even an afterthought in this judge's ruling. Now, I've talked to some attorneys since then, and they've said, well, you know, there was a lot of material put in ahead of time. And what the judge was probably saying, now the judge's whole, let me say this first, the judge's whole ruling was based on discrimination against transgender kids. But discrimination against transgender kids was not the point of this case. The point of this case was parental rights, 1, and 2, legally constructed or unlawfully constructed regulation, 2. Had nothing to do with discrimination of kids, transgender or otherwise. But yet that's what the judge, he missed the whole point of the thing. He deflected and made some ruling based on something that shouldn't have even been an issue in this case. While at the same time, as I said, ignoring the second pillar of this case, the parental rights aspect of it. Okay. Before I get into more details of what was said, I've got to also point out another abomination. Why the hell was there even a hearing? All right, let me tell you how it unfolded. Both sides, they had the hearing, started 50 minutes late, but they had a hearing. Attorney Piccirilli presented his side for maybe 10 or 15 minutes. The judge continually interrupted him, saying, come on, we already know that, get to the point. The Rhode Island Department of Education lawyer, Anthony Catone, got up, gave his maybe a little shorter response, 10 minutes. Judge never interrupted him. And then there was one more comment when Piccirilli was asked to respond for Jane Doe in response to whatever something that the Department of Education lawyer said. And then she said, okay, thank you. I'm going to take a 5-minute break and I'll be back with my ruling. And he was back within 5-6 minutes. But he had with him 30 pages or so of a pre-written decision. His decision was already made before the hearing. Why the hell did we have a hearing? You don't go type up 30 pages in all that legal format in 5 minutes. His mind was made up. Now, granted, there were plenty of materials, complaints, motions, arguments not submitted in writing ahead of time. But if he already made his decision, then why the hell was there a hearing? Anyway, that's just a side note. But it just shows you. That everything is this mind virus. You can't get through it. Now, the judges, in the heading I talked about of this show, I talked about the false narratives have infected this case. Here's what I want you to keep in mind as I go through this. The false narrative is that these transgender, quote, protections and these school policies that allow kids to be secretly transitioned, that allow kids to change their pronouns, that allow boys to play girls' sports, that allow girls and boys and the other sexes bathrooms and locker rooms or even overnight rooms on field trips, that these policies are needed to protect the health and well-being of these gender-confused students. That's the false narrative. We know for a fact now, studies have shown everywhere that children who transition are no less likely to attempt suicide or to have emotional problems than those who are not allowed to deny their gender. These are emotionally disturbed kids, no matter what is allowed, what transitional, procedures are allowed to happen medically, emotionally, chemically, hormonally, whatever. It doesn't really matter. In fact, it seems to be worse. It seems to be that children suffer more emotional damage when they are allowed to transition, because as we also know that 80 to 90% of most kids who have some kind of gender confusion grow out of it once they get through puberty. Puberty is a tough time for a lot of kids. And they grow out of it and they live a normal life. But once you go to that transition path, you basically cannot live a normal life ever again. And your risk of suicide is no less. In fact, probably even worse, depending on which studies you look at. But it's certainly arguable. So that's the false narrative, that somehow these gender-denying school policies protect kids in their health and from discrimination. And then I say, well, what discrimination? Teaching kids that sex is binary, that God's determination for you is somehow wrong. Teaching kids that delusion is I mean, where's the discrimination? What discrimination are we talking about? Any kid that's bullied should receive justice, and the bullying should stop for whatever reason. Tall, fat, short, boy, girl, black, white, gender this, gender that, sex preference this, sex preference that, dumb, smart. Any bullying for any reason is wrong and should be dealt with. But teaching the kid God's truth is somehow discriminatory? I don't understand where the discrimination is. There's the fear of discrimination if these school policies are not in place. And this is what this judge was brought into. Theoretical discrimination, theoretical bullying, theoretical harm. But in actuality, Jane Doe and her daughter were harmed in actuality, not theoretically. But that didn't matter to this judge. Completely ignored the whole parental rights. Jane Doe, who was the plaintiff in this case, was an afterthought. No, it wasn't even an afterthought. Was not even considered in his ruling. The plaintiff in this case was of no concern to the judge. He just went off in a totally different direction to justify his claim that the biological term sex was ambiguous, and therefore RI had every authority, even though not explicitly granted, had every authority to interpret sex however they want, and therefore promulgate any rule related to that they want. All right. Let's get back to some of the legal arguments. So we talked about how Attorney Piccirilli pointed out how the Department of Education unlawfully cited state law that did not exist in its defense of its regulation. That's a state level. That's state law. Federally, just in recent months, we had the Louisiana case where the Supreme Court justices said 9-0. Even the most liberal woke judges on that U.S. Supreme Court, 9-0 in that Louisiana case says that sex does not mean gender. They're different. And federal law and Louisiana law say it's sex, discrimination on the basis of sex. Gender is something totally different that is not likewise protected, at least in any stated version of the law. And we have an executive order, as the judge said, from President Donald J. Trump. Oh, the TDS disdain was just dripping as he said that. Donald J. Trump's executive order saying also that sex is not binary, and any school policies or state policies do not treat sex that way. The noun the biological noun sex, that way, are in violation of federal law. Donald J. Trump's executive order and the Supreme Court's ruling, according to this judge, has, quote, no binding effect on states or their agencies. At least not in his court. Now that's an issue that I don't know. Attorneys I've talked to don't know. Does an executive order necessarily, or does a Supreme Court decision necessarily mean that all of that has to flow down through the states? Or is that just the way the federal government has to treat this issue? I don't know that that issue has been resolved, but I'll tell you one thing. So the judge might, I don't know this, might be right in that. It has no legal binding effect, but I'll tell you what effect it can have. As you may know, as part of this whole Jane Doe, well, even before we met Jane Doe and she became a plaintiff, our law center, Gregory Piccirilli, Giovanni Ciccione, and Suzanne Cienki, our 3 volunteer attorneys, filed a referral letter to the Office of Civil Rights at the U.S. Department of Education, requesting that the Office of Civil Rights investigate Rhode Island Department of Education, Rhode Island Interscholastic League, the Attorney General, I'll get to the Attorney General in a second, and 6 school districts for implementing and supporting policies that are in violation of President Trump's executive order. So maybe it doesn't have binding effect in state courts, these executive actions and the Supreme Court action, but it certainly could give further ammunition to investigate these, to launch an investigation into these state matters here in Rhode Island, which could lead to certain loss of funding or certain other punishment, if you would, from the federal government as it pertains to dealing with state resources and whatever else. So, all right, maybe legally, but not administratively, not bureaucratically, not when it comes to President Trump's administration or federally. There may be consequences indeed for violating the Supreme Court or the presidential executive order. Maybe it doesn't hold up in court, in the state court dealing with the state issue, but there could be severe consequences. So just keep that in mind. Both the executive order and the Supreme Court ruling basically say there is no ambiguity in the term sex. Yet this judge says, well, since sex is not defined, why does it have to be defined? There's no question about it. Since sex is not defined, it's therefore open to interpretation. Truth seeker. What's the truth here? What's the truth? You and I know what sex is. Everybody knows what biological sex is. Not even the left admits that sex, the term sex, is binary, male or female. That's it. Sperm or egg producer, one or the other. Yes, there are a couple of instances of weird genetic cases, but that's not what we're talking about here. We're talking about traditional males, biological males, pure biological males, pure biological females, pretending to be something that they're not. Okay, we're not talking about these couple of worldwide instances here or there of these weird genetic cases. There is no ambiguity. This judge says that since the General Assembly did not define sex in granting the Commissioner of Education the right to promulgate rules to ensure a safe school environment for all kids, okay, that's fine. That since the General Assembly did not regulate her or define all of this specifically, that she had the right, the commissioner has the right to interpret all this however they want and promulgate whatever rules they want, basically. Now, a couple of issues with that. And I just lost my train of thought. So I'm going to go to the second one first. You might also remember a recent ruling a few years ago, actually stemmed from a case involving Gina Raimondo ruling called Raimondo versus Fisherman or something, called the Chevron case, where the United States Supreme Court said that no longer do judges have to give deference to unelected bureaucrats at all these agencies. You know, in the COVID cases that we talked about with Attorney Piccirilli, and we've seen throughout the country, on whether it's matters of environmental protection or energy or whatever it was, transgender issues, that hey, you know, we got to give deference to the agency. They're the government. You know, if there's unless there's something so obviously wrong or unconstitutional, with harmful or unconstitutional with the ruling, we gotta give them the benefit of the doubt, and we're not going to overturn any of their rules or regulations. Well, the Chevron case, the U.S. Supreme Court a few years ago said, no longer is that the case. These agencies cannot be trusted, and they should not be trusted. What's specifically written in law, you know, should be the basis, and the plaintiff and the defendant, these eight should have equal footing. If there's something wrong or harmful or unconstitutional in it, no longer do we have to give deference. Well, this judge said, yes, we do. Yes, we do. We have to give deference to it. So again, this raises another legal issue. Does this Supreme Court ruling, this Chevron case ruling that says no longer giving benefit of the doubt to these government agencies, does that mean just federal, because this was a federal case, or does it mean also trickle down locally? These will all be decided in the coming years. I had another point on this, and I'll probably remember it later on. So the judge is saying, since the General Assembly did not specifically define sex or specifically limit the role of the Department of Education, that they delegated all those future decisions to RIDE, and this judge saying, yeah, whatever RIDE says goes, since nothing is else to. How can that be? I just read to you state law that you can get a declaratory judgment to rescind a regulation if it interferes with or impairs the legal rights or privileges of the plaintiff. So what sense is that? This case clearly interfered with Jane Doe's rights as a parent. So therefore, it's up to the judiciary to decide these issues. We're the final judge, we're the final arbiter. And he even says that he even cited some trucking case where they argued, again, this is the inanity of it. This is the lack of common sense of our judiciary today. They're these tortured explanations to defend some stupid judgment. That the written plain language of a statute cannot always be interpreted to mean what it plainly says on the paper. So basically saying, we can interpret those plainly written words, even though it's obvious what their intent was. We can interpret those to mean anything we want them to mean. What the hell kind of justice is that? That we can take plain language where we know the original intent of it and try to construe it or twist it into something we want it to mean. Is that democracy? So in that case, the judge said that we cannot just look at the biological definitions and historical definitions of sex to mean what it plainly means. Therefore, Department of Education can interpret it to mean whatever the hell they want it to mean. The other argument that was brought up was Title IX by Attorney Piccirilli, and in which the judge ignored, and which the the defense, the Rhode Island Department of Education attorneys had no answer for. As you know, Title IX was said that schools cannot discriminate on the basis of sex. Universities, from universities down to K through 12, and to provide equal opportunities, right? Equal opportunities for women, the same as men. Great rule, long overdue when it came in. And then Obama, as you know, not Obama, Biden tried to change it. They wanted to add on the basis of sex, gender identity, sexual preference, et cetera, all that stuff. And there was much uproar. And I don't know if I don't think the rule ever had, it was right at the end of Biden's presidency. I don't think the rule was ever actually put in because of the pushback. But when Trump came in, he said, that's out. The original interpretation, the binary interpretation of sex that was originally written and intended in Title IX, written and intended, is back in play. Whatever Obama tried to do or did do, that's out. So that's the federal Title IX law right now. And clearly, that's the law of the land. And clearly what's happening in Rhode Island, while it may or may not be binding on states, clearly Title IX is the federal law of the land. And this Attorney General, Peter Nerona, actually wrote a Dear Colleague letter after Trump's executive order. I'm just going to paraphrase here. If I can find the actual language, I will, but I don't think I can with all my notes. No, I can't. But the Attorney General, Peter Nerona, sometime after Trump's executive order earlier this spring or late last winter, February, March timeframe, issued a Dear Colleague letter, all K through 12 school districts, basically saying, ignore President Trump's executive order. He's claiming what the judge claimed, which you wonder, are they in cahoots here? There's no binding impact of that executive order on our states and on our schools. Ignore it. And if you don't ignore it, and if you do change your transgender policies without saying the exact words, you might face recrimination from us. I mean, that's clearly implied in there. Highly recommended not to do that. So this Attorney General also, ignoring Title IX federal law, turning a blind eye towards RIDE's unlawful interpretation of state law, and just said, hey, just keep with this transgender policy. So the judge, in concluding, basically said that the biological term sex, as referred to in state law, the noun, must therefore include gender preference, gender identity, sexual preference, all that kind of stuff. And that in order to preserve a safe school environment, that was my other point I missed, a safe school environment for every student, that therefore RIDE had the right to promulgate this rule, and it must stand, and plaintiff's request to have it rescinded is denied. All right, let's talk about safe school environment. This is the false narrative. I claim, I believe with all my heart, that what we're doing to kids is creating an unsafe school environment for the vast majority of kids, and trying to create a safe cocoon for these confused young children. We are violating not only the rights of other students and the privacy of other students, but we're also violating the rights of these confused kids' parents, as is the case with Jane Doe. We are creating an unsafe environment, and it came to pass actually. They talk theoretically. This case actually caused harm to Jane Doe and daughter Doe. Actually. But yet this court and this Judge McBurney did not care. Excuse me, didn't turn off my phone. Did not care. As I mentioned earlier, Jane Doe, her story, harm inflicted upon her and her daughter, the unsafe school environment that these policies created were never brought up in the judge's ruling. Never even considered, not even an afterthought. All this judge talked about was the theoretical, well, we must protect these gender confused kids' rights and protect them from discrimination, when these rules actually didn't protect this young girl. If only we could save just one student's life, right? Theoretically. Well, in actuality, we almost lost one student's life. This is so maddening. This woke narrative, this false narrative that we need special protections for these confused children, that it protects their well-being, protects them from harm, actually puts them in more harm way, emotionally for sure, physically in many instances, and it certainly, absolutely violates the parental rights of those students' parents. So we circle right back to what I started with. Now do you see why I say that this woke mind virus, these false narratives, have infected Rhode Island Superior Court, most and many, if not many, if not most Rhode Island lawmakers, certainly the Rhode Island Department of Education. And it's causing great harm in our society. You know, in concluding here, federally and across many states, this woke myth is coming to an end. It's being exposed as untrue, as against God's truth. It's being exposed as non-scientific, scientifically based. All the quote arguments about, oh, they're not irreversible procedures, these chemicals, these hormones, these surgical mutilations, these these cutting off of body parts. Oh, it's not harmful, it's not irreversible. Yes, they are harmful. Yes, they are irreversible. But more important is the emotional manipulation, the chemical castration. All these arguments are now being scientifically exposed as false that the left makes on this transgender stuff. Federally, the rulings are almost unanimously now against this transgender agenda. In many states, they are putting in place laws that make it illegal to castrate, chemically castrate, or surgically mutilate kids who are looking for some kind of gender denying transition. And many even counties are taking similar actions. So the tide is turning, as Chris, the billboard guy who we interviewed many years ago on my In the Dugout podcast, said would happen. We will win this in the end because it is God's truth, because this agenda goes against every truth and every common sense that we hold dear. And it's turning, but yet this judge is still stuck in the woke never land of make-believe. It was stunning to see a man who supposedly is there to protect the Constitution and protect people fall completely for these false, non-science-based narratives. And Jane Doe and her daughter are suffering and will continue, and others may continue to suffer as a consequence of it. Now, will this case be appealed? I hope so. Of course, that's up to Jane Doe and her attorney, Gregory Piccirilli. I think he has the willpower to do it. Jane Doe is not been outed yet. So she's not suffering, as far as I know, any social pushback for this. So I hope she will agree to move forward. And I believe this case next time, if it's heard in front of Rhode Island Supreme Court, must include greater emphasis. It's in the complaint. And it must force the judge to rule on the parental rights aspect of this. One attorney I spoke to who tried to be a little deferential to the judge said, well, maybe the judge was saying that, all these concerns about the rights, the well-being, potential bullying, blah, 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 of transgender students make it worth the infringement on the parental rights of Jane Doe in this case or other parents. Maybe, but that's not what was stated by the judge. The judge had no consideration for Jane Doe. So if there is an appeal to the Rhode Island Supreme Court, I hope that the judges or judge or whoever will rule in that case will be forced to address whether these false narratives, these false ideas of protections, these beliefs in those woke mind virus narratives are worth or somehow justify infringement on parental rights. That's the balance that has to be struck here. Does these fictitious false narrative rights of transgender students, do they supersede the actual rights of parents? That's what needs to be addressed, and that's what this judge, whether ignorantly or purposely, declined to address. He went off in a totally different language. He used sex, the supposed or his alleged ambiguity of the term sex to justify it legally, and he ignored the parental rights aspect of it. I think we need to address to me, that's what this case was all about, parental rights. That's why we had Jane Doe as a plaintiff. We didn't have some student as a plaintiff. This wasn't about student rights, transgender or otherwise. This was about parental rights, I thought, this case. But it wasn't even considered. Wasn't even considered in the ruling. I don't get it. We'll look for other attorneys to weigh in. I'm frustrated. I'm a God-fearing guy. I'm a truth seeker. And I don't believe God's will or the truth were considered or were upheld in that Superior courtroom yesterday under Judge Joseph McBurney. So that's my long-winded Sten Reacts. You can see all my Sten Reacts segments by going to oceanstatecurrent.com, select the watch menu item from the top, and then select Sten Reacts from the drop-down that lists all our other video commentaries and podcasts that are going on oceanstatecurrent.com. So for the Ocean State Current, for the Rhode Island Center for Freedom and Prosperity, and for this Sten Reacts segment, Mike Stenos out. We'll see you next episode.